Hello, I'm attorney Scott Lesowitz, and on March 1st, 2023, the judge in the Michael Irvin defamation lawsuit against Marriott ordered Marriott to provide to Michael Irvin by March 7 copies of all the surveillance video, witness statements, and written reports about the alleged incident. That's a really big deal, right? Not really in my mind, and I'll explain to you why. So I'm going to give you a very quick background of the case, and to make it quicker, I'm going to read this part, and in order to make it less boring, I'm going to display a couple of videos of doggies playing. Michael Irvin was staying at a hotel under the Marriott banner on February 5th in Phoenix ahead of the Super Bowl. Michael Irvin, a Hall of Fame former wide receiver, was in town to cover the Super Bowl. Irvin had some type of interaction with a female hotel employee. She allegedly reported something to a hotel manager, who apparently reported something about the incident to the NFL, who pulled Michael Irvin from Super Bowl coverage. Both the public and Michael Irvin still know very little about what the female employee alleged about Michael Irvin or what the hotel manager told the NFL. It appears likely to pertain to a relatively brief conversation that Irvin had in a public area of the hotel that would have been caught by surveillance cameras. Witness statements that have come out so far about the interaction look good for Michael Irvin. So Michael Irvin filed a lawsuit for defamation and tortious interference with business relations against Marriott International Incorporated and Jane Doe. This case is now in federal court in the Eastern District of Texas. Okay, so the background is done. I'm gonna go back to just using my bullet points and rambling like an idiot. So why did Marriott put up this fight? Why was there a court battle? Well, before I get into that, please make sure you like and subscribe. It will make those puppies earlier very happy if you do. Under the normal rules of civil procedure, there would have been a delay before Michael Irvin could even make discovery requests to Marriott. And then once Michael Irvin did request that Marriott produce or provide him with copies of reports and surveillance video, Marriott would normally have at least 30 days to respond. So looking a little bit more big picture here, in case you don't know, Marriott has filed a motion to dismiss for lack of personal jurisdiction. Essentially, they argue in that motion, hey, because the alleged incident occurred in Arizona, the lawsuit should not be heard in Texas, it should be heard in a court in Arizona. And even if Marriott wins that motion, the case would still go on. It would just go on in a different court. And if you didn't know about that, shame on you, because I made a video about that motion. Tisk tisk. So because Michael Irvin did not want to wait so long to obtain the copies of the video and the reports, he filed a motion for expedited discovery to have Marriott be forced to turn over the video and reports soon. Now, Marriott opposed that motion, obviously, and they put up essentially 4 arguments. One was that they wanted to protect the privacy rights of the alleged victim. Another was that they argued that because there's a motion to dismiss pending, they shouldn't have to do discovery while it's pending. Another argument was, hey, just Michael Irvin didn't show good cause why the normal discovery timelines shouldn't apply. And then finally, they argued that, hey, Michael Irvin just wants to argue this case in the media. And for what it's worth, this YouTube attorney thinks that the judge got it right. I'm sure the judge is really, really relieved to hear this. So it's common for discovery to be ongoing while a motion to dismiss is pending, something the judge noted in the order. Also, the judge found, I think correctly so, that even though Michael Irvin really doesn't need these materials to litigate the case in court right now, the need for Michael Irvin to try to clear up his name because he's undergoing ongoing injury until that happens should be a legitimate reason to obtain expedited discovery. The judge did find that Marriott had a legitimate privacy interest in protecting the identity of the alleged victim. So what the judge did was the judge allowed Marriott to redact the name of the alleged victim from any reports and to take other steps to protect the victim's identity before providing the materials to Michael Irvin. While the order doesn't say so explicitly, I assume this means that Marriott can obscure the face of the alleged victim. So when I think of this as an upstanding YouTube attorney, I think that Marriott's strategy here was strange. I think it was inevitable that the video and reports, one way or another, were going to end up being produced. And I think that Marriott just tried to buy time, and in doing so, they looked really weak. Now, Marriott, I think, did have a legitimate concern about the alleged victim, but Marriott could have taken the position that, okay, we'll produce these reports and video, but we just want to protect the identity of the alleged victim. If they had done that and not come out against producing the materials altogether, they wouldn't have seemed weak. They wouldn't have seemed afraid by providing the materials. So in conclusion, I really don't think this order was such a big deal, because one way or another, Michael Irvin and the public was going to see a redacted copy of the surveillance video and see redacted copies of the reports.